Hey guys, and welcome to the weekly docket. Hey guys, good morning. That caught me drinking some coffee here, but let's get this puppy rolling. A lot of stuff going on after the 4th of July holidays. Let me make this bigger so we can see it. We'll hit some of the major cases that are having some updates. Start with Darrell Brooks, everybody's favorite guy to hate. And of course, his shooting charges were dealt with. The state dropped the actual shooting charges. The reckless endangerment apparently was not part of the deal. So I'm not exactly sure what the deal was, because a sentencing agreement was not part of that either, really. But the state said the witnesses were not cooperating or available. So you can take from that what you want. And he did plead guilty to felon in possession, and then gave, of course, this long speech about how he's trying to tie up loose ends and be an inspiration to his offspring. And, of course, he was lying the whole time about what he did with the gun and why he had it and all that, because that's what he does. Here was what's entered in a court record after that occurred. So if there was some confusion, as I had from an earlier hearing, that counts 1 and 2 were part of a plea deal, apparently it confused the court a little bit too, because it said pursuant to plea negotiations, and on the state's motion, counts 1 and 2 are dismissed. But at the hearing, it appears it was not really part of the deal because they didn't have the witnesses there. So again, I'm not sure what the deal was. Then you can see that the next little part there is about the sentencing. So he gets 2 years in prison for that, and then 2 years extended supervision. None of that making any difference because it runs concurrent with his existing sentences, and he's got 200 and some days of credit anyway. So it's really all just a formality. As the judge said, it's kind of an academic exercise. So what's coming up next are a bevy of charges he has related to Erica Patterson. There's several of those, and that has a final pretrial conference on the 21st of July. It's similar to what would have happened on this other case. You know, this case was going to go first, and then it got booted past the other case. So maybe something will happen this time. And a trial date of August 14th. So I'm going to try and stream this on the 21st, and I will start it a little bit early. And what I'll do for that is to show all the charges, because there are several types of charges, and they're not all about her. I think he's got a bail jumping and maybe a resisting and some other things, but just so we know what's at stake there. But anything could happen in this case. I realize that a lot of people think this is the case that he wanted to pursue because he gets to torment Erica, and I don't disagree with that analysis. You know, he's a little bit hard to predict, with the exception that what he does is always self-serving. It's just predicting in his mind what that will be can sometimes be difficult, but there's no mention yet of a plea here, so the analysis that he wants to put her through the ringer on this is still operative, I think. Now, what is interesting is the 21st, the hearing on the 21st, is still in front of the female judge, Judge Havas. And then the docket says the August 14th trial date is now in front of a different judge, Michael Hanrahan. So people wondering how he would behave in a trial with a male judge versus a female judge may get to see that if he does push this to trial, because at least right now the docket is showing this to be moved over to another judge. There's no necessarily big conspiracy behind that. I mean, sometimes it's just the timing of how the trials work out and what judges have to do with their own vacations and schedules and other cases and things like that. So that's what's showing, and it could change again, of course. So this could get delayed again, like the Sarah Boone case, and like this case did already. So who knows on that, but we'll try to watch it on the 21st and bring back up some details and see what happens with this. On his appeal, somebody said, well, what's going on with his appeal? Now, he noticed his intent to pursue post-conviction relief back in December, which he was supposed to do and did, and they were waiting on the transcripts. Now, they were due July 10th, and as of yesterday at least, there was no appeal extension docketed for those anymore. I don't know if they got served or didn't get served or what's going on with that. But if you look at this bottom piece of the slide, you'll see that after he receives the transcript or the case record, the latter of those, he has 60 days to actually file his notice of appeal. So some people have said, well, he's said this ground and that ground, the other ground. Actually not. He hasn't even filed the notice of appeal yet. He'll do that. And it may not even be a regular notice of appeal. It could be pointing to a no merit or whatever. We just don't know. And even though he has 60 days to do that, that is often extended because sometimes the attorney wants more time to review what's going on before actually putting the paperwork in. And so one of the things that in this case is his attorney that was appointed by the court is also the attorney for Chandler Halderson. And he's filing a no merit report in that case. And it looked like that was going to be turned in June, but I saw on the docket that he's got that extended till September. So he's got a few more months added on there to write this thing up, because he's probably writing a brief to show what his logic is there so the court can understand it. Because when he submits a no merit report, the court is supposed to review it and make sure that that's fair to the defendant. And that may be what happens in the Brooks case, and it may not. He may see some ground for appeal there. Everybody has different ideas on that, and the only one that really matters is his attorney's idea, and then whether Brooks will go along with it or not. So we'll see on that. I think we've got some more time to wait. All right, let's switch it out to Idaho and Bryan Kohberger, and the case that involves a lot of imagination on both sides and some facts. And we'll try to hone in on the facts, even though they're not completely known. So the gag order, of course, originally was entered, and then it was amended, and then it was amended again. And now it's been clarified rather than going through another iteration, with the judge giving a clarification that when he says attorneys and agents includes law enforcement, because there was, I guess, some confusion about that. So the actual non-dissemination order is what the judge wants to call it, not a gag order. It's fairly limited, actually, but it does include law enforcement. It doesn't include witnesses and stuff, so or family members and things, even though people thought that it did. But it also didn't get revised to exclude law enforcement, so they're not supposed to be out there giving interviews about what they think and stuff like that, and I don't think they are. One thing that happened was the defense side wanted additional time to analyze the grand jury proceedings, and the judge did split the baby on that. The judge did not move the trial date out, but he said, I'm going to give you 37 days, okay, to analyze the grand jury proceedings. And if that causes a side to need more time, then I'll find you didn't waive your right to speedy trial, and I'll add this 37 days on to the trial date if I need to. So that seems like a very fair way for the judge to handle it. The judge noting that the motion to stay is premature because it should have included the actual ground for it. But on the other hand, Kohberger hasn't had a chance really to analyze all the things that he's looking to see whether it has an error in it or not. So the judge kind of split the baby on that. This judge has been, his name is Judge, and he's been very reasonable, I think, so far. A good judge. Also, the defense gets the training records of the 3 officers that they ask for. One of the state's arguments against that was, well, then they may want training records for 300 people. And that kind of argument is limited in its effectiveness, because the judge will be like, yeah, but that's not what they're asking for. We can deal with that if they do want to do that. If they've narrowed it down to 3 people that they think it really matters for, then that could be considered a fair job by the defense to try to not be so expansive. And so when you pretend that they will be expansive, you're kind of conceding that they did your job for you and narrowed it down. And a judge notes that sometimes officers will testify on the stand about their training and experience and stuff, and how's the defense supposed to challenge that if they don't have the knowledge of that. So it seems reasonable, and I think they're going to put those under protective order so it's not out there in the public to read about, what training classes they had. Now, whether that matters or not, probably not. Most things you do in discovery don't really matter, but you never know, right? And so the defense is looking at this, and they have a right to do that, I think, to at least ask, and I think the judge made the right call here. I think he's generally doing well navigating this case, in fairness to both sides, and both sides are behaving professionally, in my opinion. Now, still at issue is this family tree DNA. Okay, so the state said, yeah, anything where we link his DNA, his profile, Bryan Kohberger's personal DNA profile to the sheath, you get that. How we linked his personal profile to his family, you get that. But what we don't want to give you is the different profile that the FBI did, where we just looked up his family tree. And the state had some good arguments for that, and some not so good arguments, like their informants, people who put their DNA in the system to see who they're related to. I mean, come on, that's pretty weak. And the defense suggested that. The defense reasons for warning it weren't the most powerful to me, because I agree with the state that what really matters is whether you're going to be able to attack that touch DNA, and there are ways to attack it, and not his family tree. Because if you show the touch DNA is not credible or doesn't prove what the state wants it to prove, then the other stuff doesn't make any difference. So I buy that, but the defense did make an argument in their brief saying that, and I'm not sure how they connect it, that the work on the family tree DNA side could have influenced how they considered the DNA on the other side. And I don't understand that fully, but if that is true, that would be a very persuasive reason to let them have this information, even in a protective order. And it's also somewhat persuasive. They're saying, look, we should be able to know the whole scope of investigation of this guy. It's not for the state to say, don't look at what we did early on in the case. That has some weight too, I think, in addition to the state saying, well, we're not going to put any of this in trial, so who cares? All right, so that we'll wait and see what happens on that. Personally, I don't think it's outrageous, whichever way the judge rules on this, because since there is an actual profile at the scene, that's going to be what's vital to either be credited or discredited one way or the other, and the family stuff's not going to matter ultimately. So I don't think this will amount to much, like I say, like a lot of these things. But something will out of all this, and that's why they should get it. So talking about evidence a little bit generally before we move out of this case, there's potentially some direct evidence in this, in that there's a survivor in the home who saw someone dressed up in the mask and all that stuff and fleeing the home. But they're not going to be able to identify who that is. So that's pretty weak, right? So sometimes people confuse, and we've gone over this before, what's direct evidence versus circumstantial, and how direct evidence often is not as persuasive or as important or as good as circumstantial evidence, because, for example, DNA is typically circumstantial evidence. Now, in this case, as far, so far as we know, they didn't find like Kohberger's like blood there and type it, or part of his body and then get his DNA off of it. They got touch DNA off the sheath, and that's a little different. And one way to attack that kind of DNA evidence is to attack the inferences necessary to connect Kohberger to the scene, because in circumstantial evidence, you have this piece of evidence, but it still leaves an inference. So if it's Kohberger's DNA on the sheath, which the state says it is, then you still have to have an inference of how it got there. Kohberger could say, well, somebody borrowed that knife from me the day before, and that would be pretty good evidence, right? But you can also attack how the DNA got there. And one way to do that is to say, well, Kohberger handled item A, which was not the sheath, and then someone else handled item A and then handled the sheath and got Kohberger's DNA on it, because touch DNA can be transferred from object to object, even by other people handling it. And I put a link to a study showing that in some other video I did. If somebody's interested, you can leave a comment and I'll post it again here, because it's a very interesting study where they had somebody or several people touch things, then grab a knife and stab a box and put the knife down and touch something else. And as it moved through sequences, they checked whose DNA was present on the knife and whose DNA was also present on the glass after that. And it was very interesting to see it. Certainly persuasive to me, to the defense point that you can have transfer of DNA from object to object. That does not mean it did happen, but it does mean it's possible. Now, on the other hand, the fact that they only found Kohberger's DNA on the sheath and not anybody else's is not a good fact for him. It's not a good fact for the manual transfer from one person picking up some of his DNA and depositing it there and not leaving any of their own. That's not impossible, of course, but you can look at the study yourself. You don't have to take my opinion and see if that happened or not. So I understand that there are issues with the DNA evidence because it is circumstantial and there are inferences, and then you can attack the procedures in the lab and how the odds are calculated and how it got there and all that. And that's all totally valid. But I've had some people arguing with me that the DNA, you just shouldn't even consider it because there's so many issues with it. And that, I doubt the jury is going to see it that way. And it's also just illogical. It would be illogical for me to say his DNA's on the sheath, he's 100% guilty, because it is circumstantial evidence and you have to have a fuller picture. But it's equally illogical to say because there could be issues with the DNA, just don't even consider it. That's just supporting your own conclusion with your own thoughts there, and not analyzing the evidence. Again, I say, if you say that neither side at this stage of the case can possibly have one point correct, then you are probably just exhibiting your own bias and not an analysis of the case. On either side, I say that. And I think he's likely guilty, but I can't say that for sure at this point. And I don't think anybody should say it for sure one way or the other. And that's my final point on that, is at the bottom, that if you conclude to a certainty that he absolutely left it there, him personally, or not, and you don't know all the facts of the case, what are you doing here? It's kind of like saying that, well, he couldn't have gone in there and stabbed them in the time frame. Well, I mean, somebody did, and they actually have a survivor who saw one person leaving, not a group of people leaving. And I'll point you to other cases like the one in Japan where the guy stabbed 45 people, killing 13, and he did it in less than 45 minutes. So that's pretty good throughput. Ted Bundy in the sorority house, killing and attacking 2 people and then attacking 2 more and only leaving because somebody pulled up, going down the street, assaulting somebody else. You might be able to say it's improbable he could do this, although I totally disagree with that. He or anyone else, I'm not saying him personally, could do it in that time frame. But if you're telling me it's impossible, then you're just making that up. It's not impossible. Likewise, I think no DNA in his car, if that's true, is a really good point for the defense, but it doesn't prove, not that he has to prove his innocence, it doesn't prove he's innocent. That's not his job at trial to prove he's innocent. It's his job at trial to prove or to show that the state has not established every element of the crime beyond a reasonable doubt. So if you say, well, no DNA in a car, it creates a doubt for me, respect. If you tell me because of that, you know he's innocent, then I have to question how many cases you've watched, because in the murder cases around here, 2 of them that were just down the street from here, they did not find DNA in a vehicle, even though that one was a brutal murder and the guy fled in his vehicle, and the other one, he transported a body in it. So yeah. Now the sheath was under, let me put this up here and mention it. Comment here, the sheath was under someone. Yes, the sheath was found partly under a comforter, I think, and partly under one of the victims. So it's obviously tied to the murder. And if you're a Kohberger defender, then you're going to say, well, that doesn't mean that he put it there. And okay, I mean, that's true. That's just where it was found. As I say, I think it was interesting that the defense said it was placed there versus found there. It's nothing wrong with them doing that, but it's, you look at how the lawyers frame cases and they're trying to steer people to their viewpoint, and placed means like a deliberate putting of the sheath there versus obviously perhaps it was likely dropped during a struggle or something like that. So I don't know. But for people telling me he couldn't kill that many people in that time frame, that's an opinion, and it may be have some weight to it, but it seems unlikely given the survivor only saw one person, and also other crimes have been committed as rapidly as that involving multiple people. So it can't all be impossible. All right. Our alarm went off. Okay. Let's go away from that case and opinions on it to Sarah Boone. And check that out. They did the status conference on that, which was supposed to be the final pretrial conference, but it was not, of course. And her attorney appeared by Zoom, and the judge talked about that a little bit. And basically what he said was, we still don't have an expert, and he put that on the rates that the county or the state wants to pay. That can be true, but it can also be true that no one is wanting to show up and say what he wants them to say, which is that she was a battered spouse. So my view is they're kind of waiting on a Dr. Bozo, a clown expert, who will come in and say that it was reasonable for her to mitigate the imminent danger that he was posing by tricking him into a suitcase, zipping him up, and leaving him in there until he died. That sounds ridiculous to me, versus the better defense of she didn't mean to do it because she was so drunk and it was totally accidental, and he was as reckless as she was, and plea bargain to a manslaughter, and you've already spent 3 years in jail, eventually get out. I think this as a self-defense case, by using battered partner / spouse defense, it almost makes a mockery out of that defense, which is a defense that I believe can occur. You can have somebody so overbearing and so threatening that you think there is no way to get out from under what they're doing except to fight back when you have the chance to do it. I mean, I believe that happens. I don't believe it's all the time or the majority of cases or whatever, but it certainly can happen. I mean, there was a saying in the Army that even no matter how big the person is, eventually they have to sleep. And that was a warning to them about how far they should be picking on people who were smaller than them, because at some point you could have it handed back to you. But I just don't see this case like that. I know he probably abused her and she abused him and all that stuff, but I don't see any evidence that she put him in a suitcase and left him there overnight to die as a self-defense mechanism. No, I don't think so. She was videoing him, making fun of him while he was in it. And it strikes me, you could have called the police while he was in there if you were scared of him, because how often are you able to catch this aggressor that you're terrified of inside of a suitcase? So whatever. I think the judge mentioned, though, in this hearing that there was another letter he said is substantially the same as the last one, but he didn't put it on the record if there was one. And maybe she complained again about the YouTube cut of the judge and people were reading her letters and stuff like that. But he did say he wants her present for the 21st hearing. And I think that's going to be just, what are we going to do to finally get this case to trial will be the nature of that hearing. And are we going to wait forever because are we waiting for the state to change its rates, which I don't know that I buy as a reason for nobody testifying unless no experts are testifying in any of the cases around the state. I just don't know about that one. I think more likely here is it's a ridiculous thing. I've never seen a case where you couldn't get an expert on both sides to say opposite things, despite the fact they're supposed to be experts and scientific and all that. So I'm surprised they can't get a bozo. We've certainly all seen them. But maybe he just needs to try harder to find said bozo or give up on this ludicrous defense. Let's leave Sarah alone to contemplate her fate as she tires of the public attention. Now let's talk about this guy, because I got asked about this in a comment. I forgot to mention it before the July 4th week. Our buddy Chad Doerman, the ultimate loser. You know his case probably by now, where he shot his 3 kids to death, his own sons. And one tried to flee and he chased that one down, shot his wife in the hand as she tried to protect a child. Just absolutely awful. And if you watch the body cam video when they went there, there's a hero dispatcher who says, at least in there a couple of times in that video, if he's not complying, go ahead and shoot him. Please shoot him if he does anything. So the dispatcher certainly caught my ear, and I appreciate that. The officers managed to restrain themselves and did not kill him, even though they found him next to a rifle. And of course, he was very compliant with the police at that point, right? So I don't know what's going on with him. But somebody said, well, how can he plead not guilty? Because he obviously did it, and he obviously did do it. Now, somebody can plead not guilty because they think they're innocent or they are innocent, right? But you can also plead not guilty, which isn't inherently the same thing as innocent, because you think that the state can't prove its case, or you want to hold the state to proving its case. Because you might have done the killing, but if the state doesn't prove beyond a reasonable doubt every element, then not guilty is the correct verdict, right? So that can be a reason for it. You may also have a justification or defense. Yes, I killed this person, but here's why or whatever. Also note that in the plea hearing where his attorney said he's pleading not guilty, they made a comment very quickly that I think I heard it right, that they reserve their rights to change pleas. And the judge said, yes, of course. Well, one of the things you can do, because I looked up the law there, is you can change before the trial. You can change your plea to not guilty by reason of insanity. And I think they've tried to get like some kind of mental treatment for this guy. And that's always worthwhile to look at if you're the defense in this case, because don't you have to be crazy to want to do this to your own children, to plot this, to kill your own children, 3 children like that. And the general sentiment would be on the street, yeah, that's crazy. But as you probably know, if you're watching this video, you're interested in crime stuff, just doing something that's quote unquote crazy is not the definition of insanity for legal purposes, which is usually that you've lost the ability to know right from wrong. Or that you were under some kind of compulsion or delusion that caused you to act the way you did. You really couldn't control it, or you had lost touch with reality. I don't think he's going to be able to prove those things here. But if you look in the Taylor Shabusiness case, they just did the hearing yesterday, or posted it yesterday, of some expert saying that she's not competent to be at trial, I think she said, but also it's going to say, I think, that she was crazy at the time it occurred, that she was hearing things and hearing voices and hearing things. And I don't know the truth of that. She definitely has a violent streak. I don't know if she was crazy at that point or not. I do believe, because of my own involvement in one of these cases, that absolutely can happen, that somebody can hear these things. They can feel they're directed to do certain acts. Now, even under the law, in theory, if a voice is coming into your head and saying, kill this innocent person, you're crazy, but you're not legally insane because you know it's wrong. Well, I shouldn't do it, but the voice wants me to do it. That's not a good reason to do it, but every once in a while that can work. It should be that you just don't know. You just don't know. So here's somebody saying, I think you're talking about this case, I don't agree with what he did, but at least he shows remorse. I guess maybe you saw something I didn't see. When I saw the body cam, I didn't see him showing any remorse there. I saw him more worried about letting the police know he wasn't going to hurt them, and he didn't want to lay on his stomach because that's uncomfortable, and come on, bro, I'm not going to hurt you and stuff. Now, he was crying a lot while he's in jail, And I don't know what that is. Is that truly remorse, or is that just the stress and shock of what he's done and now being caught for it? I don't know. So we'll have to see on that. Yeah, he was crying at the initial hearing, but sometimes people cry for themselves or when they're under stress. That was the comment. He was crying at the initial hearing. Yeah, he's a crybaby for sure. That's the picture I used there, and I think he was crying some when he was in a holding cell and hitting his head on the wall and stuff like that. Yeah, I don't agree with this guy, but I think I would have a solution that would help him not cry anymore. But I doubt that's going to happen because it just generally doesn't. But the best thing would be if he does feel remorse for what he did, because he should, because he's an absolute, the worst kind of absolute awful scumbag. I don't know why he did it. His lawyers will have to work on that. But in a case like this, I'm just not sympathetic to that. I mean, if I have a rabid raccoon in my yard, I'm not going to let it bite me every day or worry about being nice to it, because it's just too late for it. It's crazy. You got to go, bro. So if he drew the short straw and he was born kind of crazy and it results in him killing innocent children, I would move you out of the gene pool either totally or at least lock you up forever, and I wouldn't spend any time worrying about you. And I think that's what needs to happen to this guy. But that's just my opinion. I'm cold-hearted, except for at this moment. Marsha Lynn, thank you again for supporting the channel. I appreciate it. Like the Grinch, my heart is now 3 times bigger than it was a moment ago. Let's go into the pole vault and talk about the hypothetical that we had, which wasn't so hypothetical as many people quickly detected. Miranda Rights, and I gave a hypothetical here that was thinly veiled from the Megan Amirowitz case, where she threw caustic acid or a substance on her father, and ultimately he died. But she was filmed outside of a police cruiser talking to police about it and eventually admitting she threw it on him, although she denied it was dangerous. She did admit throwing it on him. The question, is that going to be allowed in court because she did not have her rights read to her? 62% said yes, it's highly likely. And in that group of people, I certainly saw a lot of analysis in there from comments that is just directly right on, right what the law says. Like, this has to be, and we'll go over it in a slide in a second, custodial interrogation, and would a reasonable person think they're free to leave and stuff. That's I like to see it, because even if you said yes or no, if you're basing it off the right analysis, then you understand what's going on and why the court might do what it wants to do. And that's, reasonable people can differ in the application of the rules, but it's first important to know what the rules are, right? And in the law, the rules are not always apparent, and sometimes they change the rules. So 28% said highly unlikely, and some of those maybe just had a different opinion on how to apply the law, and some of them maybe have thought that, well, if the police are going to question you as a suspect, they need to read you your rights, and I think that is a general sentiment out there. So nothing wrong with having that conclusion. And the always excellent answer of I don't know is also there at 10%, and I always respect that answer. So now Miranda Rights came out of the 1966 case involving Ernesto Miranda. They're not in the Constitution, right? But what it is a Supreme Court case that was designed to protect rights that are in the Constitution. And it established that certain warnings must be given regarding your right to silence and your right to counsel whenever the police are engaging in custodial interrogation. That's the key, and we'll go over that in a second. But I did want to hit this plot twist. Miranda was later murdered after being paroled, and the suspect involved in that case, at least from what I saw researching this, who potentially provided the murder weapon, a knife, exercised his Miranda rights and was never charged. So how about that? And I do have a little self-serving blurb up on the top right, which is the thumbnail for the member stream we did on this earlier this week, where we spent almost 45 minutes looking at how Miranda was developed and how it's applied, and how it worked out in lots of actual cases. And some of them are pretty weird. So I appreciate the people who waded through that long explanation. But that's what the members voted on, and that's what they got. So members vote on a topic, and then we hit it pretty hard, and it's very enjoyable. I appreciate it. So if you want to be a member, join it. You also have access to detailed videos on other topics, and they're not as kind of general as this one. All right, so what are we talking about here? The hypothetical really was centered on whether this was the police were interrogating her, right? They're asking her questions, whether it was custodial. So there's no general rule that the police can't talk to people without reading them their rights. It kicks in if interrogation is custodial. Now, if you're formally arrested, that's an easy one, right? But what if you're not? The police could still put you in a situation where you're basically in custody. So there's kind of this test, and it's an objective test. It's not necessarily how you feel, but it's how a reasonable person would feel. Would they feel like they're free to leave? All right. Could they just leave if they wanted to? Hey, can I go? And the police say, no, you can't go. Then we need you to answer these questions before you go anywhere. And they haven't read you your rights, then that might be a problem for them if you do admit something. But remember, this is the law, and there are a lot of lawyers involved in the law. So the language gets tortured and twisted a little bit. So think of a traffic stop where you are not free to leave. They pull you over with the lights, cop gets out and all this stuff, and they ask you a question, and you admit to, well, I was on the way to the woods, your officer, because I had this murder victim in my trunk. So they have not read you your rights yet. Is that going to be used against you? And you say, well, no, because they didn't read me my rights and I wasn't free to leave. But the courts have interpreted traffic stops to be of such a routine nature in society that people don't really think they're in custody then in that situation, even though for a small period of time, they're not free to leave. And that can count for DUIs too. So there are exceptions to what you might think a reasonable person would think when they're not free to leave. The law's built some exceptions into that, and some other exceptions like public safety and things that are in the longer video. So in the case that was the hypothetical that many sleuths saw through my thinly veiled attempt to hide what it was by changing the name of the person involved, you pierced the veil there and knew what had happened in this case, which was that video was admitted, right? And I watched it when it occurred, and I heard her lawyer say something like, well, did she feel like she was free to leave or something like that? And I thought, well, he's going to go after whether this is really admissible or not, but he didn't seem to pursue it very far. So it was admitted in that case. And I think the fact that she was in a public place, her friends were around, the police were just standing there talking to her, all of those things go against the idea that she's in custody versus the police are just talking to her. The only time it kind of got there, and I think from a legal standpoint, from factors that I've seen used, is when they start getting a little more accusatory, like, we know you're not telling us the truth. Come on, admit this and stuff. If you do that enough, then a reasonable person might believe, well, the police have honed in on me. They're not going to let me out of here unless I say something. But I don't think it tilted there. I think it was right to let it in that case. But that's one of those things where you might see it a little differently. But I think just talking to somebody on the street like they did in the way they did it was probably okay that they didn't read her rights first. Now, sometimes they'll go ahead and read somebody their rights, even if they're not in custody. That doesn't turn it into necessarily a custodial interrogation, but it might be a good idea sometime for the police to do that just to protect themselves, because everybody can have a different opinion. This all goes back to the idea that you have a right not to incriminate yourself, and if you're in a criminal proceeding, a right to counsel, and the idea that statements should be voluntary. So even they can't read you your Miranda rights and just beat the confession out of you, and they can't beat the confession out of you without reading your rights. And the court has said that it's not just a physical beating, but psychologically there can be a lot of pressure by the police. And when they take you down to the station in custody and you're in their possession, you're not free to leave. That's when their pressure is the highest. Okay. And so that's why they came up with these Miranda rights. They're saying we want to balance that somewhat by making sure somebody articulates to this person, who, by the way, needs to know their own rights, but the police will inform them of their rights, and they have to get a waiver that is knowing, intelligent, and voluntary. So the idea that the statements have to be voluntary and not coerced is what's really behind this. So good job on the poll. I appreciate everybody answering that. I thought it was an interesting thing that came out of this case. So when you watch these cases, sometimes you see these operative points of law that will apply generally. And when you watch the comments, you'll see people like, they didn't read her rights. This judge is corrupt. The system's corrupt and stuff. And not really, though, because you probably just didn't know this rule. It doesn't, why would you if you had never had to learn it? So that's the point of doing these polls, is to try and find some areas of law where it might be interesting for people to learn about it. And that's why I say, if you don't get the same answer I got, you might just have a reasonable difference of opinion. I could be wrong, or you just might not have learned it. So it could be one of those reasons, but I enjoy the poll, so I appreciate people answering that. All right, so I am looking here and for some comments to hit before we roll it out, because I think that's the end. One says they clearly had a drinking problem, and I think you're talking there about the Sarah Boone case, and I think that is clear too. Yeah, I think they both were probably blitzed at the time this whole incident occurred. I don't doubt that. So, I guess interesting to me is, could you see the state offering her something less than the second-degree murder because of the circumstances? And if you can, and she gets down to some kind of manslaughter territory, she's already building up a lot of time served, you just wonder if this case would plea out at some point. On the other hand, you may feel like she's totally cold-hearted, and what she did was especially egregious given the videos that were found where she taunted him as he begged, and I absolutely get that one too. So right now she's headed to trial. They haven't talked about any plea. It might help them if they did have a bozo who would say, oh yeah, she was battered and it was reasonable for her to put him in the suitcase and make videos taunting him and flipping him over and stuff. That's how she needed to handle it. You know, maybe the state would then think, well, maybe they'll get one juror who would buy that, and that can help you in a plea negotiation. But apparently bozo doesn't come cheap, is at least what her attorney is saying. And here's an interesting one. Long Island serial killer has been arrested. And I did see that just a few minutes before starting this video. So I think that's, at least on some of the murders up there, they think, and maybe more, they think they have the person in custody. They hadn't revealed an identity yet, but I'm glad to hear that. I'm glad to hear justice come, even though it may take a long time, kind of like Golden State Killer. He got away with it for far too long, absolute evil, but eventually he's where he ought to be. So this question says, those videos are admissible evidence, right? So I'm not sure which videos you're talking. Oh, okay. So I think you're talking about the Sarah Boone case. Yeah, now they'll be admissible. And here's why. First of all, it's nothing to do with the state, right? The police didn't take those videos or whatever, and she's not in custodial interrogation. So you don't have things like that. So you're really down to the evidence rules. I haven't looked it up in Florida, but the general rule of evidence is that if you have a statement against interest by a party opponent, you can admit that. It's not even counted as hearsay in some states. Even though it is hearsay, they just define it out of it. So I haven't looked at that in Florida. I'd be shocked if it's different there, because that's how it is in most places. So I think that would be the case there. So here is one. I don't remember how long Boone has been in jail. You know, sadly, I can't remember it either, even though her last letter has it down to like 8,672 hours. You know, she's like the rain woman situation. But isn't she going to close in on 3 years or something by the time they try this? I can't remember. A long time, that's for sure. So she's frustrated by that, and I understand that. But the frustration to some degree is now because she needs this bozo to testify that, or wants this bozo to testify that she is a battered spouse. There's a funny video about a woman's wig which was dragged off her head by her trunk lid. As she closed it, she wore this big wig, and it was left dangling out of her car trunk as she drove home. I thought I saw something about that, but maybe the police pulled her over to make sure it wasn't somebody in the trunk. I didn't get to see it though, but yes. Folks called 911 about it. The police got there. She was horrified to appear without the wig, but she didn't know it yet until police arrived. All right, so let's see. Check my slides here. So that's it on these cases. So next week, you know, we'll have something going on in the Boone case and in the Darrell Brooks case, and there's probably something happening almost every day in the Kohberger case, and so forth and so on. Does Sarah Boone need an expert witness for her spousal abuse idea? Now, I did do a video a while back on the law in Florida on this and read a lot about it and how it came up and how it was used. And I'm gonna say yeah, because you've got to show a mental state. Here's what it deals with. It deals with, you know, if you're on my property, break into my house, and you point a gun at me and I shoot you, then I can easily claim that I was in reasonable fear of imminent serious bodily harm or death, right? Well, how can I can't go to your house the next day and find you and then shoot you and say that, because you're not threatening me anymore. So the issue with this battered spouse is the person is not necessarily being attacked or isn't being attacked by the abuser at that moment, the person who's threatened them. So you want to show that their mental state was such that it was reasonable at that point, that because of all the things that had happened to them, that it was reasonable for them to believe then that she was in imminent fear, that every moment for her was in imminent fear. And I think you would need an expert for that. I just can't remember if the case said you had to have it or not. It was more about whether the law would allow it, and they did have experts in those cases. I'm not sure you could do it without one, or if you tried to, it'd probably be extremely weak, because the state would get an expert who would say, no, absolutely not. I don't really care about the law. I care about a juror's reaction. Well, the individual jury doesn't care about the law either at this point. And sorry, I'm losing track of which cases those go on. If it's a Sarah Boone, well, yeah, I hear you on that. You've got to think what's the juror going to do. But there are also certain jury instructions and certain floors you have to meet before you can put things in. And what I can't tell you is whether the judge would allow it if you didn't have a certain minimum of this, that, or the other. I just don't know for sure. But I don't think I think you probably. I agree with her attorney in this respect. I would not want to proceed into the trial without a bozo up there talking about how crazy that she was at that time, or her mental state at that time. Kind of like Shabusiness has an expert saying that she was crazy at the time she dismembered her boyfriend. You're trying to testify at somebody's mental state and how it was. I think you'd want that. Will Erica Patterson be at the hearing for the final pretrial conference? I don't know that she would be, or any reason for her to want to be there. And he may come by Zoom or whatever. But as we talked about, trial is a different situation. And I think we covered that one hard several times about whether somebody has to be in a courtroom or not and what they have to do. And another question, do I think Brooks behaved himself this week because he thinks it will help his appeal? I don't think so. I mean, it really shouldn't be relevant to his appeal one way or the other. Now, somebody did bring up an intriguing theory in a comment saying, maybe he's behaving because he really believes that his appeal is going to work. And if he gets his convictions thrown out on the parade attack, having this ridiculously minimal sentence will help him get out of jail. I don't know that or necessarily agree with that, but I thought that was an interesting thought. Now, some people said, well, he was behaving this way because the judge was a male and he would behave with a male judge and not with a female judge. And that's an interesting thought too. Maybe we'll find out, because now the trial for Erica is currently slated to be in front of a male judge, switching off of the female judge. So we'll have to see. But the second female judge has been pretty polite to her too during the hearings. Anything Brooks does is just for himself and only for himself. So you have to try and put yourself into his mindset to decipher what he's up to. And that can be a little difficult. And it might be the case that since really what was happening to him there had no negative consequences for him as long as he didn't do anything bad. He just went along for the ride, and it makes him look better. He's trying to be an inspiration to his children. I think Eric will be at the next trial in the Brooks case that involves her. I don't think she would let his family intimidate him. Yeah, now if she doesn't show up, that's good for him, because he's not going to be convicted, I don't think. I would doubt it. I mean, maybe they'd be able to get some of the intimidation stuff in, but she needs to be there if she wants to see him have a punishment for this because of the Sixth Amendment. And in fact, these shooting charges, the DA was saying, hey, we have to drop these charges because we can't really get these witnesses to come, the people who were shot at. All right, we'll do this one real quick. Would you please explain what a no merit report is? So in Wisconsin, when you get an appeal attorney and you're criminal or you're convicted as a criminal, the attorney evaluates the appeal, right? And if they see a basis for the appeal, then they file the appeal. If the attorney evaluates the record and sees no reasonable basis for the appeal, they don't have to put their license on it. They're an officer of the court. They didn't put their signature and their license on the line for that. So what they do then is they can file what's called a no merit report, which goes to the Court of Appeals and says, I've evaluated this record and I don't find a reasonable basis for appeal. And the Court of Appeals will look at that and make sure they agree with it, because maybe you just did a terrible job, and they can assign a different attorney or tell you to go back and look at it again or something like that. But assuming they accept it, you're done off the case then, and the person does not get another paid state attorney at that point if that happens. But the rules also have some things in it about discussing it with your client before you file a no merit, and there's a detailed video on that in the past. But that's what it is. So his attorney will have to look at the whole record and say, well, I think there is a reasonable basis for appeal, or I don't. And he didn't in the Halverson case, so he's filing a no merit report in that case. And like I say, he got an extension of time. So the actual report's not going to be just one page of, I think this is stupid. He's going to have to write out what he looked at and why he doesn't think it worked, and and stuff like that. And he'll do that for the Brooks case. But he may find a basis for appeal. That's his job, is to look fairly at the record. And it's not his job to go, well, I think this guy's a scumbag and did it, so I won't file his appeal. His job is to be unbiased, analytical. Well, if he has a bias, he should be biased in favor of his client within the parameters of the law, right? So he shouldn't be biased against his own client just because he's a scumbag. So he will look at it, but on the other hand, you don't have to just throw up any frivolous thing because your scumbag client wants you to do it, like sovereign nonsense and stuff like that. So if there's a lawful basis for an appeal, he should file the appeal, even though the guy's a scumbag. And if there's not, he should not. The Brooks denied current mental health treatment, but his mom said in the hearing that he's mentally ill, needs help. The system failed him. Well, it's interesting because I think he did say in this that he's not on any medication or drugs or whatever, yet he's the best behaved he's ever been. So he's also not self-medicating, perhaps. And it could be the fine glasses that he has now letting him see the world in a whole different way. I think the judge went easy on Brooks because he's already in jail for life. Yeah, well, yeah, probably, because the judge did say that this is just an academic exercise. So, yeah. Look at this. I'm going to pump. Thank you very much. But it came in just under the wire. A new member. And love my vet off grid. I think I read that right. Well, I'm almost an off grid vet myself. So respect. Let's see here. Well, guys, I appreciate you guys tuning in for this. And if you have questions and stuff, I try and accommodate it as I answer comments, and also look to you for ideas about the cases that are interesting. You've thrown some cool ones out here, or what you think are confusing areas of law that we could talk about that would help all of us learn a little bit about it. And I think that is about it for the docket. And everybody have a good weekend, and I will talk to you later. That's it. Thanks. Bye.